This matter is before the court on the plaintiff's motion for emergency hearing regarding the anticipated proposed sale of the marital home. This hearing is being conducted via Zoom. Present is Attorney Kirsten Umek, representing the plaintiff. Zach Ray Garcia. Mr. Garcia is present. In addition, Attorney Teresa Ouellette is present, representing the defendant Michelle Garcia, and Ms. Garcia is also present. Also appears we have a realtor, Chris Hudson, also present this morning. Good morning, everyone.
Good morning, Your Honor.
Morning. Good morning.
Good morning, Ms. Patrick. The parties have conferred with Ms. Patrick at length this morning. Ms. Patrick is recommending to the court that the marital home be sold for $355,000 with 30 days occupancy for the defendant, as the marital home will be sold as is. Ms. Umek, is this recommendation good with your client this morning?
It is, Your Honor.
Right, Ms. Ouellette.
Unfortunately, Your Honor, it is not. My client feels that the offer is too low. The homes in the area were selling for $420,000. When Your Honor originally ordered that the house be listed, he did say that the parties would make repairs to the home and divide the cost of those. However, the parties decided against that. I did get her to accept the offer that was originally put in, which was $20,000 more. And now Ms. Garcia, being faced with another $20,000 reduction after reducing the price for listing so dramatically, she disagrees and feels that maybe they should go the route of making some repairs to increase the value of the home. This is, essentially what Ms. Garcia has to find another home for herself and her 5 children.
So the original offer was $375,000. That was accepted. Is that correct?
It is.
That's correct.
And with 30 days occupancy, correct?
Yes.
And after the inspection has been completed, is that correct? And that showed deficiencies with respect to furnace, other issues, and that resulted in because of that inspection, there was a reduced.
That's correct.
That's correct. And that was anticipated when we were here on November 6th and November 7th. And it's the reason that the language regarding following the reasonable advice of the realtor was included in the last order. We specifically discussed any issues that would be turned up upon inspection and how the parties should proceed through any reduction in the offer because of those issues.
And I'll just have the court know that the price and what they argued why the price should be so low is because there was anticipated issues with the home.
No, that's actually not accurate. The reason that the price was so low was not the anticipated issues. It was the issues that were visible at the time. The house is not comparable to the other houses in the area. And quite honestly, Ms. Hudson can probably speak to that with more authority than anybody else can. But it's not accurate that we anticipated that the furnace was failing, that there were carbon monoxide levels that were 50 ppm, that there were 53 circuits in a 40 opening panel, that almost every window was failing, there was mold in the basement, leaks in the basement due to cracks in the walls and the floor. No, that wasn't anticipated.
The furnace was because they've already gotten they already received an estimate through someone that the realtor recommended for a replacement of the furnace. And with regards to the mold and the damage in the basement, that was already known because that was due to an insurance. They made an insurance claim for those same issues. So those things were known.
And had been remediated already. And now they are back after Ms. Garcia's exclusive use of the property.
Ms. Umek, in your pleadings, you suggested that buyers have agreed to a $15,000 price reduction with 30 days occupancy.
They did. I'm sorry.
What happened with that? Now there's a suggestion it's a $20,000 reduction.
I believe that the email from Ms. Hudson was included in the exhibits. She said that they would agree to $15,000 if Ms. Garcia responded in the next 2 days. But if Ms. Garcia forced this to go to court, that they would go back to the $20,000 reduction. And obviously we're here, and Ms. Garcia still is not agreeing to accept the reduction in the offer. despite Ms. Hudson making it clear and her advice being that they should. Today, the delay is now I want to make the repairs that previously we discussed and we decided not to make. Now she wants to make $40,000 of repairs to potentially increase the price. In the meantime, we lose the one offer that the parties have received. The house has been listed since August 19th. And in the interim, Mr. Garcia pays every expense. When we were here on November 6th and 7th, my motion was to set aside the status quo and replace it with orders of support so that Ms. Garcia would start to be responsible for her own expenses. We set that aside. We did not pursue that because it was our understanding that an offer had been accepted, that the parties were going to accept all of the reasonable advice of the Realtor with regard to any changes in that offer, again, specifically discussed on November 6th and November 7th. And that, you know, we were going to close toward the end of this month. Instead, it's November 25th, and issues that were found upon inspection caused the buyers to reduce the offer just as I anticipated, just as we specifically discussed, and we're in limbo.
And she
Ms.
keeps
Nemec?
saying that she didn't anticipate, or that one argument is that she didn't anticipate that these repairs need to be made, but then the other hand, it is. We reduced the price. She agreed to reduce the price. There was an inspection because of all the issues that are known clearly. And now there's a $20,000 price reduction. And this is Ms. Garcia, unlike Mr. Garcia, doesn't have a home already purchased where she can go with her and her 5 kids. So she's anticipating trying to get the most out of the home. And now it's being reduced by $20,000, which is a significant amount for her.
Understood.
May I say
Ms.
one
Nemec,
thing, Judge?
Ms. Nemec, is it too late is the $15,000 reduction, is that still acceptable to the buyers, do you believe, in your discussions with Ms. Hudson?
I don't believe it is viable, but I did just hear her ask if she could say something. So could I ask
Oh,
Ms. Hudson directly?
you've had an opportunity. She's been involved in these discussions. The question is, the court's inclined to, if in fact at one time they were agreeable to $15,000 reduction, why not to sell it for $360,000? The occupancy should be clearly 30 days. This divorce has been pending for almost 1 year. So whatever dollar amount this court decides, it's going to be a 30-day occupancy.
Understood, Ms.
Question whether
Hudson.
it's sold for $360,000 or $355,000. So the question is it too late? I don't know when the buyer said, oh, we did agree to a $15,000 reduction if we had a response within a couple of days. I don't know how long ago that statement was made.
That was on November 18th. So my understanding would be, and I'll ask Ms. Hudson to clarify for me if I'm wrong, but my understanding would be that they wanted an answer by the 19th. And that they very clearly communicated that if there was any delay past that point, or we had to go to court to address this, that it would go back to 20,000. I think that's in Exhibit E. Yes, Exhibit E on November 18th at 11:14 a.m. Ms. Hudson stated that the buyers are willing to drop the price by 15,000 as long as this gets signed in the next couple of days. That's as low as they will go. Then she addresses the 60-day occupancy and why that's not possible. And the last paragraph says, please call me if this needs to be explained. Buyer's agent stated that if this is not agreed upon in the next couple of days and it has to go to court, they will ask for the full $20,000 price drop.
All right, the court's obviously read the pleadings. The court's ordered that marital home be sold for $360,000 with 30-day occupancy for the defendant to be sold as is. So Ms. Hudson, go back and the $15,000 reduction is acceptable with 30 days occupancy. That's all. Sale price should be $360,000. And if
Your
in
Honor,
fact they back out, they walk, then so be it. It'll stay on the market.
So Your Honor, if they back out, can we have orders of support rather than the status quo?
We
And
put
have-
this back in our docket. Let's put this back in our docket by the end of the week, and then we'll know then whether or not the revised the counteroffer has been accepted.
Your Honor, it's Thanksgiving on Thursday.
Okay, how about Wednesday then? Late Wednesday morning? We'll know. Obviously, Ms. Hudson will know by Wednesday, correct?
Yes, I should know by Wednesday, correct.
Okay. What time do we have, Andrea, on Wednesday?
I understand time is of the essence here, but my office is booked on Wednesday. There's only
Is
two of us.
booked? Or you
Yeah.
booked, or you-
Yeah, one of us is out and the other one has court.
well, this court's booked to 2 on Wednesday.
Oh,
Okay, let's do it late Tuesday afternoon then.
okay. Yeah.
Your Honor, I will be in mediation with Mr. Godfroy, but I'm sure I'll be able to pop out for a little bit.
What time do your mediation start?
9 o'clock. It's on the Calkins
Okay,
matter.
I'm thinking late in the afternoon. It's any time in the afternoon, whatever is good for you, Miss Olet. So let's do it.
Yeah, I'm fine. Whenever in the afternoon is fine with me.
Gonna do 3 o'clock, Miss Nemec?
That should be fine.
Oh, it's on Tuesday? Yeah. Okay, well, how about we'll start this for review, Miss Patrick, if you could revise your recommendation, sale price be $360,000 with 30 days occupancy. And the court will review this matter on Tuesday, November 26th at 3 p.m. Ms. Hudson, will that give you
Yes,
enough
John.
time to see whether or not it's acceptable?
It should. It just depends on how quickly the buyers will get back to me. I will reach out to him today.
Wonderful. Hopefully that will work. Anything further, Ms. Nemec or Ms. Olet?
I have nothing further. Thank you.
Nothing further. Thank you, Your Honor.
Okay, we'll see you on Tuesday then. Well, actually tomorrow at 3 o'clock.
Okay, thank you.
Thank you, Ms. Hudson.
Oh, thank you.
Ms. Nemec, have the parties made any progress toward their own resolution this morning?
Unfortunately, Your Honor, no, they have not.
Okay. What is is there any value in a second mediation, or do you want simply a trial date?
Your Honor, this was our third mediation. I think at this
Oh.
point, we need to set this for trial.
Okay. How many days do you anticipate the trial, Ms. Nemec? 1 day? Could we do it in a day?
I think it would be at least 2. I think every issue will be preserved for trial. I don't think we have resolution on anything.
Okay, the court noted that in the pretrial statement some time ago, the only issues were spousal support, real property division, and pension benefits. Is
Correct.
custody and parenting time now an issue?
It is,
It is.
Parties are going backwards.
yes.
Mr. and Mrs. Garcia, I will tell you right now, obviously, if the two of you cannot reach your own agreement, which is far preferred rather than a trial date, it will create problems because when spouses testify against each other, they're always going to want to put the other parent in negative terms. You're going to start throwing stones at each other, then you're going to start throwing rocks at each other, and it's going to destroy your relationship to co-parent your children. I can tell you that right now from past experience. But if in fact you want to put yourselves in that position, court can't do much about that, but I would encourage you to keep an open mind and reach your own agreement. And you sort of lose control because what this court will do is most likely just liquidate everything. We're not going to argue over a lot of items. We're just going to liquidate everything. Much easier to divide cash than to divide property. The home is on the market now. Is that correct?
Your Honor, an offer has been accepted. We've been back before the court a couple of times on this. We were here in early November.
Correct.
The closing's tomorrow.
Oh, wonderful.
But that does
Okay.
raise an issue, Your Honor. We request that the proceeds from the sale be held in IOLTA because currently everything is at issue and there's nothing that's been agreed upon. And we have some serious issues with regards to some bank withdrawals after getting subpoenaed, the results of subpoenas from bank records.
Your Honor,
Any
if I may.
objection?
So, Ms. Olet, did you receive the 4 sets of answers to interrogatories that my office sent to you after the November hearing where we discussed this?
Yes, and we went through and tallied and got our subpoenas for the bank records. There is about $70,000 in withdrawals taken out outside of the $30,000 that's accounted for payment of loans and credit cards.
Any objection, Ms. Nemec, to placing the net sale proceeds into escrow, into a client trust account?
I have no objection.
All right, and who wishes to hold those funds?
I will hold them if that's fine.
That's fine.
All right, so the court will order that the net proceeds realized from the sale of the marital home, which is to occur tomorrow, which is December 13th, it shall be maintained in the deposit, maintaining the client trust account of Attorney Umek.
Your Honor, in addition, we are going to need some temporary orders from the court. Ms. Garcia has indicated, so she has 30 days occupancy of the marital home, and that will end on January 12th. She has indicated she intends to move to the Dearborn Heights area. Mr. Garcia lives in the Trenton area, so neither party will continue to reside in the children's current school district. An issue at mediation this morning was where the children would go to school. The parties do not agree on that issue. Mr. Garcia would like to see them go to school in Trenton, where he owns a home. Ms. Garcia's intent is to stay temporarily with her grandmother. That's our understanding. And so her living situation wouldn't be necessarily permanent or stable. In addition, Mr. Garcia believes that the school districts in Trenton are superior to the schools that are available where she intends to reside in Dearborn Heights. I don't know, how long she would be there and if there would be a change in those districts if she found a permanent situation in a different area of Dearborn Heights. But at least temporarily, we are going to need to address that issue because as of January 12th, neither party will reside in the Ida School District where the children currently attend school. In
How old are the
addition,
children?
And we would object to that, Your Honor.
How old are the children, Ms. Nemec?
the oldest is 11, the youngest is 2, and there are 5 of them. So they range
So-
from
And-
11.
And my
So 4 of the
client,
children are in school in Ida?
Currently, yes.
Okay.
And
Mr.
my-
Lett?
my client is going to reside with her grandmother in Dearborn Heights schools. My client is the primary caregiver when it comes to the minor children's school. The fact of the matter is that dad during his parenting time has not been getting the children prepared for school. Instead, he's been bringing them back to Miss Garcia to get them dressed and ready for school at the conclusion of his parenting time, rather than taking them to school and having them properly ready. Further, my client has gotten messages from teachers saying that on dad's parenting time during the week, that the minor children are coming to school tired, and they're just not ready for school. So we would ask that school remain with mom, as she is the person who is getting the children to school, getting them prepared, doing the homework, taking them to extracurricular activities, participating in concerts and everything else with the children, and she will remain and continue doing so. So we ask that
Right,
it be in
Is
Dearborn Heights.
Mr. Pratt still available? I'd like to, the court would like to get a recommendation from Mr. Pratt this morning. And absent agreement, the court's inclined to suggest that children remain in Ida schools. Why should we disrupt their lives because of the parents? Mr.
Your
Pratt,
Honor,
do you have any recommendation for relative to school placement of the children?
Well, my understanding is both parties are going to be living in Wayne County, so I do not believe Ida schools will allow the children to stay in the Ida school district. It's my understanding with both parties not even living in the county, they would not even be able to do school of choice. Currently, the parenting schedule is dad has 6 out of 14, mom has 8 out of 14. We struggled with this for a while, Your Honor, and I'm not sure which way that would go, because dad's in Trenton and mom's going to be in Dearborn Heights.
Understood, but again, the children are already enrolled in Ida. I don't think Ida's going to boot them out because a parent moves.
Once
How
mom
do they get
changes her
know that
address,
parent
there's
moved?
no guarantee, Your Honor.
Michelle, have you looked into whether the children can remain in Ida schools for the remainder of the school year?
I have, and they said that once school of choice opens up again, they could remain in Ida schools.
Well, that's usually at the beginning of a commencement of a new school year.
Yeah,
So unless the court receives a letter from Ida schools that they cannot continue after January, then the court's going to order that they continue in Ida schools.
Thank you, Your Honor. We would
And you
prefer
have to
that the
disrupt their
children.
lives.
Okay.
So if you want to prepare an order, Ms. Nemec, that unless the Ida school refuses to allow the children to continue, they shall continue in the Ida schools. And the court suggests parents don't make it an issue. If it's not an issue, the Ida school is not going to unilaterally hire an investigator to find out if someone's moved. You've got to somehow transport the children to Ida schools every day. And if
Yeah.
Mr. Garcia is late and not delivering the children on time, then the court will modify the parenting time schedule.
Your Honor, I would like to address that since it was stated on the record, and I'd like to remind the court that previously we had to argue when Ms. Garcia was represented by Mr. Clark. We were having trouble with parenting time while Mr. Garcia was exercising in the marital home because Ms. Garcia was going so far as to lock up food and toiletries. The reason Mr. Garcia was bringing the children back to the marital home to change clothes was because Miss Garcia was not allowing the children to have their clothes with them, and they were picking up the bus from the marital home. At this point, with Mr. Garcia living in Trenton and having a home of his own, as long as Miss Garcia doesn't continue to withhold the children's property, he would be getting the children ready for school and transporting them directly to school, not having to bring them to the marital home to retrieve clean clothes and get on the bus. So there should be no issue there as long as Ms. Garcia doesn't withhold any property.
All right. All right. Hopefully the parties can work through these issues together. But if not, you're requesting that we set a trial date at this time, is that correct? In the trial court docket?
Yes,
Yeah.
Your Honor, but we will also have one other issue that needs to be handled in the interim. We have a status quo in place. And obviously the marital home will be sold as of, well, it's sold as of tomorrow, but she won't be occupying it anymore as of January 12th. So we would like to see that status quo replaced with support orders. We'd have no problem with carrying it through for the remainder through January. Mr. Garcia gives her $350 a week, plus pays all of the marital expenses. We would like to see that continue through January, and then in February, spousal support and child support. We were unable, though, to run any new numbers this morning because it's my understanding the system is down.
Correct.
All right. What about if we simply refer the issue of child support and spousal support to the front of the court for an investigation recommendation?
I think that would be sufficient.
I don't have objection to that.
Okay.
You can include that in your order then, Ms. Nemec. If you get that order,
Okay.
we'll get that entered as soon as possible, that the children should remain in Ida schools until further order. And what this court's looking at is we need something from Ida schools that they're removing the children from schools. And I doubt they will do that unless one of the parents contacts Ida schools, say, oh, you know, we're no longer living in Monroe County. I don't think that's going to be an issue. And then the children we need to minimize disruption for the children, Mr. and Mrs. Garcia, to make it work. Even if one of you needs to, I don't know how long Mr. Garcia's lived in. Obviously, Mr. Garcia is a plaintiff, so he moved out of Monroe County shortly after filing the divorce complaint. Is that correct?
No, that's not correct, Your Honor. Mr. Garcia continued to, he stayed with family members and continued to exercise his parenting time at the marital home until just maybe 2 months ago, I believe, is when he purchased the home in Trenton.
Okay, well, maybe mom can find an apartment temporarily in Monroe County. So there's no issue with disrupting the children. Think about your children, Miss Garcia. And then Mr. Garcia, maybe you can find a temporary apartment. We're talking about 5 months, 6 months. Let the children finish where they're at right now. Let's minimize disruption to their lives. And all of a sudden changing schools, it's enough with the parents getting divorced, but it compounds that issue for the children when they're taken out of their school they've known and put in a whole new environment. So again, you can put that in your order that the issue of child support and spousal support should be referred to front of the court for formal investigation recommendation. The sooner we get that order entered, the sooner we can address that matter, hopefully in January.
Thank you,
All
Your
right,
Honor.
let's get some trial dates. And you want to set it for 2 days. So we're probably looking at Thursday and Friday. Absolutely.
13th and 14th, Thursday and Friday.
How about February 13th and 14th? It's a Thursday and a Friday.
Hold on one
We
second.
need it to be sooner. They go on winter break.
That works for me, Your Honor.
Unfortunately,
Lett?
we already have something on the 13th.
They have a trial date on the 13th.
Yeah, so our calendar already has a date on the 13th. We have two, it's just myself and Miss Smith, and both of us have prior hearings on the 13th.
Okay, can that be moved? Is this a hearing? Can Ms. Smith handle the hearing?
No, I'm saying we have two. Both of us are covering a hearing on the 13th. The 14th
you
is
need-
okay, but I don't have the 13th. I have the 11th and the 12th.
No,
It's just
the court docket days are Tuesdays and Wednesdays, so the court wants to do it 2 consecutive days. So you're not available on the 13th, then, correct?
No,
Okay, and that,
I'm sorry.
how about the 20th and 21st of February?
May I speak? May I speak?
Just a moment, ma'am.
Those dates work for me, Your Honor.
Yeah, I'm okay with that day too.
All right, the court will set the 2-day trial, February 20th. It'll be in person, beginning at 8:30 each day. The court will request that the council submit trial briefs, exchange and submit trial briefs and exhibit lists on or before February 14th. Court will mail out notice. Ms. Garcia, do you want to talk with Ms. Olet?
Yes, I would like to do that.
Okay, we give you a breakout room.
Thank you.
Your Honor, I believe that in order to release the escrow funds to me, they're gonna need an order, and the closing is tomorrow. So I'm gonna get that order prepared right away.
Okay,
And just send it over for signatures so I can get it to the
that's
closing.
fine. That's right. Ms. Olet is a consented to that on the record, so you can just submit it directly to the court for entry. So you have it for closing. Ms. Olet, I'm sorry, I've got another matter waiting.
Oh, yeah, I'm sorry.
So
My
I just wanna bring it
apologies.
Back out.
My
Do you want-
my client just has raised an issue that, with regards to the schools, she said that it would be an hour drive for the children from Dearborn Heights to remain in Ida schools. So she asked that the court reconsider Dearborn Heights schools, as that's kind of a
Now
long.
without hearing, Ms. Olet, the children will stay in Ida schools. So hopefully, I mean, it's going to be an issue for both parties and a greater issue for the children. This court's concerned about the children, not Mr. and Mrs. Garcia. So that will conclude this matter. Maybe the parties can talk and agree upon something in the interim. Maybe somewhere between Ida and Trent. But the court's not going to make a decision without a full hearing on that, and that will be occur in February.
Okay.
Do you want to talk with Ms. Umek? If you, I can put you all four in a breakout room if you want.
No, I can talk with Miss Nemec after. I can
Right.
give her.
Ms. Umek is going to submit an order today for the court to sign, so we get an order for the closing agent that the net proceeds be held in escrow by Ms. Umek. So she'll be submitting that today without your approval. And there'll be a second separate order regarding the other issues, the schooling. I believe, and referring the issues of spouse support and child support in front of the court, you can do a separate order for that, Ms. Umek.
Okay, or Miss Olet, if you're available to review it right away today and sign it electronically, I can combine it all into one. I plan to do it right now.
Okay, yeah, if you do it right now, I can do that. I have a hearing in Livingston at 1:30.
Okay,
I'll
all
go
right.
together right
That will
now.
conclude this matter. Everyone zoom out and have a good rest of the morning.
Yes,
Thank
thank you, Your Honor.
Thank you.
The guy makes over $100,000 a year. My client makes $800 a month.
She locks up all of the food, the toiletries, and requires him to bring food for himself and the children 3 nights a week.
But he's just stopping over for 10 minutes here and there, and it is disruptive to the family. It's disruptive to the kids.
However, Miss Garcia literally locks up the toilet paper.